Office of the Solicitor's Honors Program, staff attorney with the Native American Rights Fund, and 14 years in a private solo practice in Pendleton, Oregon. There he represented the Confederated Tribes of the Umatilla Indian Reservation as general counsel and also represented the tribe's housing project and prosecuted criminal cases before the tribal court. He served as chief counsel for the Nez Perce tribe from 1989 to 1999. From 1999 to 2005, Mr. Nash was head of the Indian Law Practice Group at Holland and Hart, LLP. He served as Associate Professor of Law and James E. Rogers Fellow in American Indian Law at the University of Idaho College of Law. In August 2005, Mr. Nash became Director of the Institute for Indian Estate Planning and Probate at Seattle University School of Law, where he also was an adjunct professor of law. The Institute evolved into the Center for Indian Law and Policy, which continued the work of the Institute as well as other programs and projects, including a tribal dispute resolution project. Mr. Nash served as Chief Judge of the Warm Springs Tribal Court of Appeals and as an appellate court judge for the Tulalip, Sauk, Seattle, Grand Ronde, Nez Perce, and Nooksack tribes. He also served as a pro tem judge for several tribes at both the trial and appellate level. He continues to serve as an associate judge for the Umatilla Tribal Court. He is a former member and past secretary and president of the National Native American Bar Association, past board member of the Northwest Indian Bar Association, and secretary-treasurer of the Indian Land Tenure Foundation Board from its inception until resigning in May 2005 to assume the position of director of the Institute. He has been a member of the New Mexico, Oregon, Idaho, and Washington bars and is admitted to practice before the state and federal courts in those states, the U.S. Court of Appeals for the Ninth Circuit, and the United States Supreme Court. He resigned his memberships in good standing in the New Mexico, Oregon, and Washington bars upon retiring from Seattle University, however, retained his membership in the Idaho State Bar. Other memberships have included the Federal Bar Association and Indian Law Section, the Indian Law Sections of the New Mexico, Oregon, Idaho, and Washington Bar Associations, the National Native American Bar Association, and the Northwest Indian Bar Association. Please welcome Doug Nash.
Thank you, everyone, for being here. The time I need is cut very short because Ms. Scott covered half of what I had prepared to say. And with that kind of history, you'd think I can't hold down a job. But keep in mind, it has been 50 years. And I want to thank Dan Kane, too, for putting this event together and some of the others that have been presented here. I think it's a great idea and a great opportunity, and I appreciate the opportunity to be here. 50 years of tribal law implies a number of things. It is obviously specific about time. 50 years takes us back to 1971. And just this past week I was going to say cruelly reminded, it wasn't cruel, but reminded anyway that it was 50 years ago this year that I graduated from the University of New Mexico School of Law, and I received in the mail a nice picture of our graduating class of that year, a whole bunch of kids who look like they're about 13, and a commemorative pin as well saying that I've survived 50 years as an alumni of that school, which I am actually very proud of. And when you're my age, I don't think anybody here is, but it seems like it was only like last week when my primary concerns were an upcoming high school basketball game and where I might find some gas money for my 56 Chevy. Those were the important issues in my life at that point in time. But time does fly. And I frequently get reminders about the passage of time and age and what it means and what it doesn't mean. Some of you may have known my aunt, Miley Lawyer, who, longtime resident of Lapwai in this area, and whose house I now reside in. She was always fond of coming up with some language that would shock people from time to time, but she would tell me regularly in her later years, "Don't get old, son, it's hell." And of course, being a wise guy, I'd say, "Okay, I won't." But here I am. And it maybe isn't quite hell, but it's pretty close. Recently, too, I was reminded I was talking to another elder, who was even more elder than me, and I was lamenting age catching up with me, and the things it meant I couldn't do anymore, and things I would like to do. And he asked me how old I was, and I said, "Well, I'll be 75 at my next birthday." And he waved me off and he said, "You're just a junior, senior." So I had to think about that for a while. I'm not a full-fledged senior yet. I'm just working my way up and in junior status. The title of the event tonight also mentions wisdom, and tribal people around the country almost uniformly equate age with wisdom in one way or the other, in their legends and their beliefs. I've heard that most of my life, and I've got the elder part down, but I'm still waiting for the wisdom to catch up with me. I hope it's coming. I'd like to briefly go over some of the things I've done in the last 50 years, mainly things that Ms. Scott had mentioned, because they all influence me one way or the other, and influence my thought process and in my direction for my career. As she mentioned, I graduated from the University of New Mexico. I went from there to Washington, D.C. for the Interior Solicitor Department's honors program, and we lasted less than a year there because I couldn't adjust. Maybe we all, my wife Phyllis and I, couldn't adjust to living in a city like Washington, D.C. It's a far cry from Winchester, Idaho. I worked after that for the Native American Rights Fund and gained great experience there. Worked primarily on natural resource cases, worked with the former David Getches, who was the former director of NARF and who since has passed away, and worked with him on the U.S. versus Washington litigation that was going on in Washington state at that time. I spent 11 years in private practice at Pendleton, where I worked in a number of positions for the Umatilla tribe, and then came back here to serve in the first in-house Office of Legal Counsel program. From the OLC position, I worked with Holland and Hart, which is a regional law firm headquartered in Denver, with offices around the Rocky Mountain West, including Boise, where I nominally had an office. My real office was in Green Creek, Idaho, which drew a lot of surprises from attorneys in that firm when they found that out, since they didn't know where Green Creek, Idaho was. After that, I took a position at the University of Idaho College of Law, which was an education for me, appropriately enough. There I taught civil procedure, water law, Indian law, natural resources, and criminal law for a period of about 3 years. I then went to the Seattle University School of Law, where I had the opportunity and fortune to organize and create the Center for Indian Law and Policy, and also the Indian Estate Planning Project, which was a program under which we trained law students to do basic estate planning, will drafting, powers of attorney, and similar documents, and then sent them out to work on reservations for the summer months. And we had from 9 to 15 students out in any given year. And those students did an amazing volume of work and an excellent quality of work, and provided a very important resource, I think, to tribal members across the country on the reservations that they served. One of their primary goals in doing estate planning and specific training that they received was to reduce the fractionation of ownership in trust allotments. And we had gone through and identified a number of ways in which that could be done, and gave them those tools to work with as they talked with tribal members about their estate planning. Excuse me. And as Ms. Scott mentioned, I served in a number of judicial and judicial type capacities for 8 tribes in the Pacific Northwest over a number of years, and that was my retirement plan, if you will, a number of part-time jobs that would keep me busy and keep my mind busy. I found early on that 8 part-time jobs adds up to about 1.5 full-time jobs. And so I cut that back to the one position that I continue to hold with the tribal court. Looking back again to 50 years. 50 years is a long time in history. When we think about history, for example, for the Nez Perce tribe, the thought process usually goes back to Nez Perce War, Nez Perce treaties, the Allotment Act, and other events like those that happened well before our current 50-year period. When we talk about history in the last 50 years, there's kind of a blank. There isn't a identifiable event that stands out. There isn't a book that talks about Nez Perce history in the last 50 years. But history is made every day, and it's made every day, has been made every day in the past 50 years as well. And I think that is an important point to make, and one I want to make tonight, because that kind of history is important for any nation. It's important for the world. It's important for cities, counties, and organizations, and it's certainly important for Indian tribes. The importance of history has been recognized by a lot of famous people, and if you go on the internet to look at what people have said about history and its importance, you'll get a flood of information. It is obviously a very important topic to a lot of people. And there are a couple of those observations I'd like to share with you tonight because I think they underscore the point I want to make and hope to make with you tonight. Robert Heinlein, a novelist, said that a generation which ignores history has no past and no future. And if you think about that in our context today, have we ignored history? Have we ignored our own history? Is there a generation amongst those of us who are alive today who have a firm grasp on our tribal history and what it means and what we can learn from it? And I don't know the answer to that. My feeling is that it is a neglected point. It isn't a focus, and perhaps it should be. There is another famous quote that struck me, and it's one I know most of you have probably heard, and that is that those who do not remember the past are condemned to repeat it. And the lesson from that quote, I think, is that if we don't pay attention to those kind of events, major events that shape our history, if they were in error, we may be bound to repeat that error. If they were in error and we pay attention, maybe we learn how to avoid that error in the future. And of course, if it is a positive result and a positive outcome, we should have the common sense to recognize that it's a pattern we should follow. Now, because my background is all legal, I wanted to give you a couple of examples about possible lessons, historic lessons that exist that we should know about and draw on. My first is this, and I guess before I go that route, I wanted to say that preparing for an event like this, I always worry, am I going to have enough material to fill an hour's time? And then as I get into it and I start reading and researching and writing, I soon find I have enough for about 4 hours of law school classroom time. So Dan was a little worried when I said I got 3 hours to present and the doors need to be locked until 9 o'clock. And there will be a test. Did you know that within the past 50 years, the existence of the Nez Perce Reservation has twice been in jeopardy? And by that I mean the reservation faced the prospect of being disestablished, that is, the boundaries being erased and the reservation no longer existing. Twice that has happened. It's clearly a lesson that needs to be looked at and we need to learn from. And I want to talk as briefly as I can about two specific cases where that issue was raised. The first is a case from 1998. It is from the Ninth Circuit, U.S. Ninth Circuit Court of Appeals, and it is County of Lewis versus the Nez Perce Tribe, the Nez Perce Tribal Court, and the judges of the Nez Perce Tribal Court. And this case arose because a Lewis County deputy was called to a disturbance in Lewis County, obviously, and arrested a tribal member for disturbing the peace. And this happened when there was only the deputy, the person arrested, the complainant, and one other person present. And the state trial court dismissed the case because the only person disturbed was the deputy, and that doesn't stand up to the test of disturbing the peace, and so the case was dismissed. The next move was the tribal member sued the deputy, the sheriff, and Lewis County for false arrest, assault and battery, false imprisonment, and malicious prosecution. And that suit was brought in tribal court. After a jury trial, damages were awarded to the plaintiff against the deputy, the sheriff, and Lewis County. The damages were prorated, so they were divided up amongst all the defendants, and the plaintiff actually bore some financial liability in that case as well. An appeal was made to the Nez Perce Tribal Court of Appeals, where the trial court decision was affirmed. The county defendants throughout this case, of course, claimed that the tribe had no jurisdiction. It had no civil jurisdiction over non-Indians generally and them specifically. The county defendants then filed a suit in U.S. District Court making that claim. And under the law in existence at that time, that could happen if the defendants had exhausted their tribal court remedies, which they did by going through tribal court and then the Court of Appeals. There was no place else for them to go. And so the federal court agreed that it had jurisdiction to hear this case. And it was presented, and the court examined it under the principles of a U.S. Supreme Court case called Montana versus United States. And that analysis goes on and on and on, and to try to put it in a nutshell, that case says that generally there is no tribal jurisdiction over non-Indians, but there are exceptions. And there were two exceptions that were recognized and discussed by the court in this case. One exception is when there is a consensual relationship between the non-Indian person or entity in the tribe. And the other is when the non-Indian conduct affects the political integrity, the economic security, or the health and welfare of the tribal entity. So those are the two exceptions the court has. The court also has before it, however, a resolution passed by NEPTEC in the 1950s. And that resolution, I'll read you the key whereas, says that the Indians residing on the Nez Perce Indian Reservation are desirous at this time of having the state of Idaho assume and exercise criminal jurisdiction over offenses other than those commonly known as major crimes committed by Indians residing on the reservation. So this was not something that passed under Public Law 280, but was an action taken by the tribe itself. The court looked at the two exceptions and said that the consensual relationship doesn't work because in the Montana case, the consensual relationship was a commercial one. It was a business. It was a contract, work for money and that kind of thing. The court also held that because of the NEPTEC resolution that was passed, the arrest of the tribal member by a county deputy did not bear on tribal government. In other words, the tribal government had given its blessing for that kind of action to take place. So the case was remanded back to the district court, and the district court upheld or issued the order affirming or upholding and giving effect to the Ninth Circuit decision that the tribe had no civil jurisdiction over non-Indians. On the remand, which is when the court sends it back, when the Ninth Circuit sends it back to the district court, they remand the case there. The county, when they moved to have the case remanded for an order from the district court, moved to have the remand include a determination that the Nez Perce Reservation had been disestablished. And the court declined to consider that request, along with two other requests made by the county for remand. So it's a seemingly small piece of a much bigger case, but it is a bullet that was dodged, a very near miss, if you will, because although we ended up eventually in another case with the right decision, in terms of disestablishment, the preparation for making those arguments hadn't been done at the time of this case by 1998. And so while we could have responded and would have responded as vigorously as possible, it would have been an effort shorter than the one we put in at a later time. The second case deals with a federal criminal prosecution. And this was a crime committed by a tribal member within the reservation on land that was once a trust allotment, but which had been taken out of trust and was held in fee from 1908 through the present time. The defendant filed a motion to dismiss that criminal prosecution for lack of federal jurisdiction, claiming that the lands that the tribe had ceded to the United States and the allotments that were made and which were subsequently put into fee status were no longer part of Indian country for purposes of federal jurisdiction. The definition of Indian country in federal criminal statutes is all land within the boundaries of an Indian reservation, notwithstanding fee status, trust status, or otherwise. But their claim was that the reservation had been disestablished, that the reservation boundaries no longer existed, and so therefore this was no longer Indian country and there was no federal jurisdiction. We learned early on that the U.S. Supreme Court decisions involving disestablishment of reservations are very few and far between. For such a seemingly important topic, there are only 6, 7, or 8 cases from the United States Supreme Court on that topic. The structure was such that in the allotment process, which took place for the most part in the early 1890s, that the government couldn't pursue or couldn't affect the allotment of a reservation until they had an agreement with the affected tribe. Now, keep in mind, the United States and tribes for years interacted on agreements via treaties, but Congress had passed a law saying that the United States would no longer enter into treaties with Indian tribes, and so therefore the agreement is what took that place. The agreement with the Nez Perce tribe was pursued in 1893, and the side story of how that agreement was reached is yet another sad chapter in history, and it is aggravating when you look back at it on how it was done and how it was handled. Whether there's a lesson to be learned from that, I'm not sure. But the U.S. representatives met with people who were guiding tribal government at the time and said, we need to reach an agreement because you have, quote, surplus lands. You have lands on your reservation that you don't need, and we want to take them and sell them for you. And you'll still have your own allotments for your homes, your gardens, your horses, your cattle. Tribal representatives repeatedly said, no, we don't want to have our reservation allotted. No, we have future generations coming. We have huge herds of horses and cattle, and we need all the land that we have. We need the resources, we need the timber, the roots. That exchange went back and forth for a number of meetings. And eventually, the United States representatives gave up, and instead of concluding an agreement with the tribal leaders at the time, what they did was they went from house to house, household to household across the reservation and asked the heads of households, do you agree that the reservation should be allotted? Do you agree we should buy your surplus lands? And they did that until they had what they calculated to be a majority of the heads of households. And that is what they took back to Washington, D.C. Now, of course, you can imagine in 1893 with the reservation as it is and people spread out, the population spread out across the countryside, how much individual heads of households knew about what was going on and what allotments were and what it meant generally. But that was how the agreement was obtained, and it was presented to Congress. The primary rule regarding the disestablishment of Indian reservations is that once Congress establishes a reservation, only Congress can disestablish it. Seems pretty simple. But as we've seen the Supreme Court do in a number of areas, the court began to water down that basic rule and begin to change the parameters by which disestablishment could be considered. For example, they said, well, that's true, but we have to look at the demographics. How many non-Indian people are there on this reservation compared to Indian people? We have to look at land ownership. How many non-Indians own land on this reservation compared to non-Indian land ownership? And they began picking away at these points which are irrelevant to congressional intent. The second rule that came out of that picking away process was one that establishes a very high bar in disestablishment cases. And that rule said that if the agreement for the allotment of the reservation contained language of cession and some certain, it establishes an almost irrebuttable presumption of disestablishment. So, language of cession, that is, the tribe cedes this land, cedes its title to the United States. In some certain, the United States agrees to pay 36 cents an acre for that land. And if those two elements are in the agreement, and in our case, the 1893 agreement, there's an almost irrebuttable presumption that the reservation has been disestablished. And those two terms are in our 1893 agreement. And an almost irrebuttable presumption means that it is about 1/1000th of an inch from going over the top and concluding disestablishment. The Nez Perce Agreement actually says in its specific language that the Nez Perce Indians hereby cede, sell, relinquish, and convey to the United States title to the surplus lands. In another section, it says that the United States stipulates and agrees to pay to the said Nez Perce Indians the sum of $1,026,222. So cession, some certain, there it is. And that is the obstacle that was faced in this case. And it gets even more complicated and more convoluted because there were other cases going on at the time that involved disestablishment. Yankton Sioux had a disestablishment case pending before the federal courts and pending before the U.S. Supreme Court. The Yankton Sioux agreement, which had a different date than ours, contained the same language. It contained language of cession and language of some certain. And the Supreme Court looked at the facts in the Yankton case and said, Yankton is disestablished. And then they put in their opinion a note in the text that said that the Nez Perce allotment agreement was ratified by Congress the same day as the Yankton Sioux agreement. And that popped up as a red flag. This was an era, some of you may recall, when an organization called the North Central Idaho Jurisdictional Alliance was active and had members that included cities and counties, school districts, highway districts, and other local governmental entities. And their avowed purpose was to defeat any aspect of tribal jurisdiction over non-Indians. The red flag we identified in the Yankton opinion led us to believe that this was a door opening for the alliance, that they would seize on that language and think this gives them an opportunity to press for the disestablishment of the Nez Perce Reservation. So within OLC, we began researching and preparing almost immediately. And we reached out to a number of sources and resources to see what we could find and see what arguments might be developed to counter this almost irrebuttable presumption. And this took place over a long period of time, a lot of detailed work, and if we went through it, we would be here for another day, but I'll try to capsulize what points were important in what we worked on. First of all, there was no language in the 1893 agreement that mentioned disestablishment or even hinted at it. And Congress, of course, knows how to disestablish a reservation, and they've done it before. And they didn't do it in the 1893 agreement. The 1893 agreement contained a savings clause that said all prior treaties would remain in effect, and assurances were given that that was the case. The tribe was concerned about that possibility, and they were told, no, that would not happen. And the 1863 treaty, of course, contained a description of the reservation boundaries. And so the implication was that those boundaries still existed and wouldn't be changed. The court looked at the cession in some certain language and said that in the context of the Nez Perce case, it's illogical, that it doesn't make sense. And one of the reasons they found this was we presented evidence that there was no word in the Nez Perce language that equated to cede or cession. Cede is a technical term that involves not only the transfer of ownership, but a transfer of authority and jurisdiction over something. In discussions and in the minutes, the transaction was described by tribal representatives as being a trade. This was a sale, and they equated it to a transaction in which a horse was being given and funds received for it, and a commercial transaction, if you will, but not a cession. We researched legislative history. We had a research organization in Washington, D.C. go into the National Archives with the task of finding every piece of federal legislation that contained the words Nez Perce Indian Reservation. And of course, there are quite a few of those around. When the 1893 agreement was negotiated, the United States sent out a commission comprised of 3 individuals to engage in those negotiations with tribal leaders. And that ended up being one of the smoking guns, if you will, that we did come across. One member of that commission ended up being the acting commissioner of Indian Affairs in later years. And somewhat as a fluke, there was a map company in Portland, Oregon, that sent a map to the Commissioner of Indian Affairs in Washington, D.C., and asked if the depiction on their map of the Nez Perce Reservation was accurate. So this acting commissioner, who was one of the people that negotiated the agreement, said in a response, "In reply, I have to advise you that the boundaries of the present Nez Perce Reservation appear to be correctly laid down upon the map enclosed by you. If by diminished reservation you refer to the cession of the surplus lands of that reservation made by a recent agreement with said Indians, I have to advise you that said agreement makes no change in the boundaries of that reservation." And that was probably the biggest hammer we had in terms of evidence supporting the non-disestablishment of the reservation. From 1893 forward, the treatment of the reservation in jurisdictional history was important. There was correspondence recognizing the reservation. There was a federal presence on this reservation from that time, even before then, but from that time forward to the present. The way right-of-ways were established confirmed that this was a reservation. There were liquor laws, BIA services, and a host of other points like that that would not be made if the reservation was not in existence. Interestingly, I thought, the court in this criminal case cited the Lewis County decision, where it was noted in that decision that the reservation encompasses nearly all of Lewis County. So we got a little piece of payback from the Lewis County case. The court also found that altering the reservation boundaries would alter the status quo. That is, it would create a jurisdictional nightmare if instead of having Indian country contained within one specific geographic unit. It would be a trust parcel here and a trust parcel there and a trust parcel here. And for those events and crimes that required specific location on federal trust property, it would be truly a nightmare. So the court ultimately agreed with our position and with the evidence we presented, and said that the almost insurmountable presumption of disestablishment has been overcome, and held that the reservation was not disestablished. That finding by the U.S. District Court was affirmed by a very strong opinion issued by the Ninth Circuit Court of Appeals in the year 2000. And that stands now, 21 years later, as the state of the law in terms of the existence of the Nez Perce Reservation. There are two other cases that I want to throw out, and I'll do so very briefly, believe it or not, that contain some important lessons. Back around 1990, the United States Congress passed a statute of limitations for damage actions by tribes against individuals and private companies. Statute of limitations say there's this amount of time that you have to act, and if you don't act within that time, you're precluded. And there had been statutes of limitations created for actions against the United States, but never for individual people and entities. Research began on that, and we found a number of cases, some of them quite small, where there were potential damages. We looked at what claims had been made in the past, and what we found was that there were never claims made for damages caused to fish runs that were subject to treaty reserved rights, caused by Idaho Power's dams in the Snake River, Oxbow, Hells Canyon, and Brownlee dams. Those dams early on had some tinkering to try to create fish passage, but they were unsuccessful, and ultimately they blocked the Snake River from the lowest Hells Canyon dam upward. Claims were never made for damages caused by the Washington Water Power dams at Lewiston and on the South Fork of the Clearwater River. The Lewiston Dam, the most recent, had a fish ladder that allowed steelhead to pass but did not allow salmon to pass. And so the salmon runs in the Clearwater from nearly the confluence with the Snake were eliminated and destroyed. The South Fork Dam blocked the river totally, and no fish went beyond that. And as an aside, there was an opportunity to make a claim for fish damage to fish runs caused by Dvorak Dam and on the North Fork. And that opportunity had a time limit on it commensurate with the construction of the dam, and that opportunity was forfeited. There was never a claim made for that loss. The Idaho Power lawsuit was filed in 1991 before a U.S. magistrate, which is kind of a lesser version of a U.S. district court. And from there it went to the U.S. District Court, and a summary judgment was granted in favor of Idaho Power Company in 1994. The tribe appealed that decision to the Ninth Circuit, and mediation was suggested, discussed, and agreed to, and it was begun. That mediation extended over 3 years. A mediator was identified, agreed to by the parties, and a grueling mediation process began, meeting with the mediator, the parties meeting together, meeting separately, traveling to different locations for meetings, doing the background work that would support our respective positions and claims, and eventually, In 1997, an agreement was reached as negotiated by the mediator. As a result of that agreement, among a number of other side and collateral issues in terms of money damages, Idaho Power agreed to pay the tribe $11.5 million. They also agreed to pay an additional $5 million if the tribe would support Idaho Power's relicensing application for the Hells Canyon Dam Complex. Those projects have to be relicensed every so often. Ultimately, the tribe did not support the relicensing application, and I think that application process is still pending even today. The Washington Water Power case was filed in 1991, and summary judgment was granted in favor of Washington Water Power in 1996. Again, an appeal was made to the Ninth Circuit Court of Appeals, and there, this time, the Ninth Circuit ordered mediation. And so another mediation process was begun, and in 1999, there was a tentative settlement. And this came after 3 years of mediation. The process of finding mediators that both parties could agree to in both of those cases was, as you might expect, a tricky process. There was distrust and suspicion. If they liked this guy, we probably didn't like him. And if we suggested somebody, they'd think, oh, this guy's going to be more in favor of the tribe. And that process by itself probably took 8 months. But ultimately, that tentative settlement was reached. It was presented to the court, and it was approved by the U.S. District Court and entered into. Again, there were a number of side issues that confirmed interaction between Washington Water Power and the tribe, and opportunities, employment, right-of-ways, a host of things. But getting it down to the bottom dollar, Washington Water Power agreed to pay to the tribe $2.5 million upon the signing of the agreement, and agreed to pay $36.7 million over the next 44 years. And so that process is ongoing. So my pitch here is that we can look at cases like this, and there are many others, and we can learn from these historic events. As I mentioned before, we can learn what happened that was good and what happened that was bad, and we can adjust our future actions as a result of that examination. What we can draw from them can guide our future actions and future decisions. Now, who does that speak to? Interesting for us as individuals, but we aren't the decision makers directly. NEPTEC members, program directors, managers, staff with decision-making authority are the people who need to know and have a good grasp of these historical events. It should be learned by all so that the lessons these events teach can be applied to our everyday circumstances. And it's important to note that these are not limited to legal issues or legal cases. There have been a host of events outside the legal arena that are historic and profound when we look at them in today's light. A few examples. The acquisition of the Maloney Creek property, off-reservation transaction negotiated with others from outside the tribe, agreement ultimately reached, and the land put into tribal ownership. The acquisition of the sacred lands in Northeast Oregon and expanding that into Southeast Washington. huge step and a huge transaction and a very positive outcome in many respects, from an economic standpoint, from a political standpoint, from a resource management standpoint. Those were major events. The securing of the wildlife mitigation funds for Dvorak Reservoir, that was a real coup. The mitigation funds for fisheries had come and gone, but the wildlife mitigation funds had not been spoken for, and the Wildlife Department went after those and secured those funds and developed appropriate and sound programs. Fisheries Department planted coho and other species on streams outside the reservation in the face of severe threats from the Idaho Fish and Game Department. But the planting went on in any event, and I'm gratified to see within the past year, maybe a year ago, article in the paper saying, oh, now people can fish for coho. And the sole reason they can is because of the steps that the Tribal Fisheries Department took to put those out-migrating fish back into the river system. Acquisition of the Clarkston Golf Course, an important step economically, again, and politically, something that has the potential for yielding a lot of benefits beyond just the mere entertainment of golfing. There is a lot of significance attached to that particular step. The development and operation of this facility, of having this casino, the opportunities it presents for employment, presents for economic benefit to the tribe. It provides entertainment, and it too has a host of benefits. I actually thought I'd have a bigger draw than Cheech and Chong, but oh well. And my point, if I haven't made it already or hammered on it, is that this recent history is important, and as it should be. In future years, people will see that some of these events, or maybe all of them, were as important as some of those events that took place back in the 1800s and early 1900s. They will have an ongoing impact. Now, the history in its entirety is not probably important to every aspect of tribal government. People within fisheries probably don't necessarily need to learn the lessons of litigation over jurisdiction. People in the forestry department probably don't need to know the activities and the significant events that were masterminded by the fisheries department. Tribal court issues may not hinge on land acquisition decisions, and so on. So the whole concept is that there needs to be a source of Nez Perce history. If it were put into one book, a source of Nez Perce history in the past 50 years and developed ongoing into future years, if that were done, the book would be huge and be difficult, I suppose, to navigate. But it can be broken down into segments by topic, by tribal program interest, by time, by chronology, a number of ways that it could be indexed and available. And so the challenge, if you will, that I make here is to ask that that project be begun and an effort made to organize those with the capacity to develop and document that history over the past now 50 years and to maintain that history on into the future. So with that, we'll begin the test. Thank you.
Well, thank you so much. I'm impressed. I'm usually having to give people that look of time's coming up. That was wonderful, though, and we do have some time for some questions, and I know we have folks here that have questions. We have some microphones up front, so please come forward, and Doug is here to answer those questions. Who's first? He did. Covered everything. Yeah, come on up. I believe these microphones are on.
Great listening to you, Doug. It was a great history lesson. I'm glad I brought my notebook because I was writing a lot. And as a program director, I'm glad that I got a firsthand lesson on what we should know at the Nez Perce tribe on the front line. I'm glad that you're supporting the idea that we begin to catalog our history the last 50 years, but as I look the last 50 years is also to, I guess, navigate how, as a program director, manager, person in the front line, how we move forward in our frontline services to our community. I'll explain two situations that I think about a lot. And I'm from the education department, and some of our education partners are organizations that have made public statements and support on issues that the tribe disagrees with. And so one of those is Perpetua Resources, formerly Midas Gold in the McCall area. Another one is where I saw recently where another large manufacturer, the CEO, spoke about how he opposes the removal of dams. And so I guess it'd be good to know that where do we draw our boundaries when we build, because building relationships is going to be really important with what we do and access to other resources as the tribe, builds our nation, working with others. And so I maybe just get an idea from what you think. And I was going through my junk room. I have a corner of papers that I've kept for a number of years, and 2 weeks ago I ran across the papers from that meeting we had with the Alliance at the Red Lion in Lewiston. And at that time, there was a talk about an agreement. What can we do to work better together for the next 20 years? And I always wonder about that. What did we do out of that document, working towards building relations, intergovernmental within this reservation area? So just some of my thoughts on my mind, because legal issues are important to the tribe, but I guess we work with the Nez Perce tribe, defining our boundaries on how we navigate our relations with others is helpful for me. So.
Thank you. I think that's several good points. It's up to you as a program director interacting with other organizations in the same field to determine how you can best do that. And perhaps there is some guidance in some of these other events and some of the other past agreements that have been put together by tribal programs with outside entities. But ultimately, it comes down to you at your level and role to shape that for those particular issues. Good points. Thank you.
Oh, there it goes. Well, thank you, Mr. Nash. We appreciate all that you've done in your life and for the tribe in general. And we definitely take the challenge to record our history. And I know we've talked about that previously with our committee and with our Office of Legal Counsel, and developing an archive and a new governance center, and that'd be part of it. But my question is for you is, I'm sure you're familiar with the Cougar Den case. The Cougar Den in White Swan, Washington, was hauling fuel into their fuel station. They were tribal members, and in the opinion, of course, the the Supreme Court upheld that decision that the Cougar Den was within their rights, within their treaty right to haul fuel into their fuel station without being taxed by the state of Washington. And in the opinion, there was a portion in there that had stated about the Washington cigarette state tax, which the tribes faced, and at the time of negotiation of compacts for their casinos, were leveraged by the state to either accept a compact with the state or with the cigarettes. You know, one way or the other, the tribes couldn't get both. So in the opinion, I believe, or may have been actually at the Supreme Court in the questioning, was that I think it might have been Justice Breyer, had mentioned that, well, if this is overturned, or if the court rules in favor of Cougar Den, could this unravel the cigarette cases in the state of Washington? And so I know that's a difficult question to ask without reviewing the full Cougar Den case and the cigarette cases that are behind that. But I'd just like to kind of maybe hear some of your thoughts on that type of thought process of Justice Breyer in the Cougar Den case in the opinion.
Thank you. I have to confess at the outset that I'm not hugely familiar with that case or the background behind it, but I think what you describe is a piece of the lesson that we learn from litigation, and that is, what do judges and courts in the Supreme Court, justices, look at? And when there are concerns like that, or when it's possible to point those kind of outcomes out to a court, it's important to do that when it works in your favor. It is akin to pointing out to the court that if the reservation boundaries were disestablished and we had little pockets here and there of federal lands that where federal jurisdiction would apply, it would be a nightmare for law enforcement and others. So, as you say, there are numerous cigarette tax cases out of Washington state, and I'll have to claim ignorance about the impact between this decision and those. Best I can do, sorry.
Well, thank you for that, Doug. I appreciate that. And, you know, I'm not here to try to turn this into general counsel or anything like that, but just appreciate you being here and offering your history and your knowledge to us. And I feel like I'm a lot more educated now than before I walked into this room today. And I appreciate the encouragement for the purchase of the Red Wolf Golf Club too, and the opportunities that are there for us.
It's a good step. Mr. Wheeler said when I came in the room he was glad to see me here. I said, wait till I'm done talking and see if you still feel the same way. And apparently he does, and I appreciate that.
All right, any last chance questions? Well, I just want to take this opportunity to thank you, Mr. Nash. I realize in the work that I do how important it was to have these champions and leaders pave this path so we can be where we are today and continue to make the moves that we do. And that is thanks to people like Doug and those before him too, so thank you. Appreciate you being here. Give Doug a round of applause. And just on a side note, I do want to thank the Clearwater River Casino for putting this event on. This was our second Nimiipuu Speaker Series, and we are going to take a break for the summer as we do have several other things coming up. However, we do hope to continue these come fall and winter, so stay tuned. And if you know of anyone that has missed these sessions, they have been recorded and the videos will be put out for viewing at a future date. So we'll put notice out when those become available. Thank you so much and have a wonderful evening.
Let me add one thing, if I could. I'd like to step out by thanking you all for coming here tonight and sharing this time. I know everybody has busy schedules, and I appreciate you taking the time to join us and be here. I was pleased to see a lot of people I hadn't seen in a while, and after seeing some of the folks who were here, I had to change some of my comments, but it worked out. Thank you again.